The record reflect we are back in session. The parties and counsel are present. Counsel wanted to be heard before we resume with closing statements.
Yes, Your Honor. Defense wanted to be heard on the admonishment to the jury before it's done. Since I wasn't here the day this happened, I reviewed the transcript. And based on my review of the transcript, there was discussion at the time when Mr. Robertson was going to be called. And there's objection to what he could testify to, and there's discussion with the court and counsel about what can be testified to and what can be argued. The court started out with the idea both sides are allowed to comment on the not calling of logical witnesses. That's allowed. And they said, well, they're calling Mr. Robinson, and they're going to say that I tried to locate him. He said, that's allowed. But he couldn't say that he's hiding. The court would say, no, he can't testify to that. And also he said, you can't argue that because that would be speculative. And they said he also must testify about efforts of Mr. Cavanaugh to make sure Ms. Rico Bene was not able to be located. The court said, no, that's also speculative. You cannot testify to that, and you cannot argue that. The court did not say, we could not say or argue that he's a logical witness to call. That is not what the ruling was of the court. The court's ruling was very clear. You can't argue speculative nature of whether or not he's hiding, whether or not he has a conscious guilt of hiding. Any of those things is what the court, the terms the court used. And so to say, to admonish the jury that I mentioned they didn't call a logical witness, that would not be a violation of the order, because that is not what this court said. It starts on 7668 and goes on for about 6-8 pages. That's probably why the court doesn't remember that, because that ruling would make no sense, according to even the court's own statement during the discussion of that. That's common. That's a standard argument to argue they didn't call logical witnesses. And
of course, it doesn't make sense to argue failure to call a witness when the evidence is there was an attempt to locate the witness to get him here, but he couldn't be found.
Well, there was the testimony that the defense tried to. I don't know. There could have been. I don't know of any evidence of what the people tried to do to present him. I don't think they did call a due diligence witness for that. So the fact that we tried and wanted to call them will at least give us factual basis to not have a credible argument among the people. Well, if they made a big deal about Dan Cavanaugh, they should have called him. The only other time that a party could be precluded from arguing that is that the witness is excluded from testimony based on some court's ruling, which we don't have here. If they take the fifth and the court says, no, you can't call them, or they're a by law, an unavailable witness, I'm making that finding. Then it would be misconduct to say they should have called him because we knew the court made an order or a ruling that precluded from that to happen. That didn't occur here. So there's nothing in the record and nothing in the court's ruling to say anything I said violates the court's ruling, and so I would ask that the jury not be admonished and let the defense and the people just argue how they want to argue as long as it's within the facts.
People should be heard.
Yeah, I mean, the court was pretty clear in response to our clarifying question by Mr. Anonymous.
What? Go ahead and read it to me.
So, I can put it up on the screen as well, if you'd like. Okay.
The court should probably read the whole transcript because what they're going to do is try and read the one line where it was interrupting. Can we do this? The court says yes, and they go on to a different topic, and the court then makes its rulings very clear.
I think it's my floor right now, so.
Go ahead.
Thank you. Can I have my computer, please?
Waiting a second for it to...
Okay, go ahead, scroll down. Oh, it keeps going down. Okay. Okay, keep going. Okay, keep going. Okay, keep going. Okay, keep going. Okay. Okay. Okay, keep going. Okay, keep going. Keep going. Keep going. Keep going. Going. Keep going. Keep going. Keep going. Keep going. Keep going. Keep going.
Keep going.
I think we're well beyond that issue. So go back to the very beginning.
Starts on 668.
Okay. before that, right at the beginning where you first started the first time. I don't know what page you started.
Oh, okay.
Lower.
Right here.
So at the very beginning, Mr. Imes says, implicit in that ruling is forbidding either side to make a closing argument. The argument of failure to call logical witnesses as to Mr. Cavanaugh because it would be speculative. Court indicated, yes, Mr. Imes interrupts. So if it's speculative, then it's not relevant. The evidence of it would not be relevant. The court then went on, I think they're entitled to put on evidence they attempted to locate him. And then the rest of the discussion was what would be speculative would be that he was hiding or there was a consciousness of guilt. So I apparently did initially indicate that that I would preclude argument on failure to call witnesses, to call logical witnesses as to Mr. Cavanaugh. So I'm willing to admonish the jury that the court had previously ruled that.
That's what we're requesting, Your Honor.
Okay.
The defense would object because that is not clear what the court's ruling is. The court's ruling was you could not argue he was hiding or consciousness of guilt. That's talking about whether or not it's speculative. Yes, it's speculative, and this is entitled. And why would the court single out one witness versus another? To say that now there's a ruling which would not match any amount of proper argument case law that I know of is, I think, setting a poor precedent to calling out defense counsel for something that, one, is not clearly stated, two, would be contrary to all established case law. And again, focusing on punishing the defense when the people have never been punished in front of the court. That's a whole different issue. But I do not think it would be appropriate to say, I violated some order, when one, that order was not clearly given, and two, that order would be contrary to all known case law of what is expected of counsel in the closing argument.
Mr. Imes said so they would be precluded from arguing failure to call logical witnesses as it relates to Mr. Cavanaugh. The court said yes, and then when there was the rest of the discussion, you are correct. Points out that the rest of the argument had to do with whether it showed consciousness of guilt, whether he was hiding, whether he was trying to avoid service, or Mr. Robertson just wasn't good enough to find him when someone else might. I think if there was a question about that, then it was incumbent on the defense to say, wait a minute, how can you say we can't argue failure to call logical witnesses just because we couldn't find them? So I think prosecution is right. The court answered Mr. Imes' question, and I think counsel, at a minimum, if they thought that was wrong or thought that needed to be clarified, should have clarified it.
And just so the record's clear, I did not see anything there. And I don't know if I'm wrong, if there's something else that was said. Did they ever make an offer of proof that they tried to locate him? My guess is no.
There was no evidence one way or the other.
Well, we presented evidence that we tried to, and you
Correct.
allowed us to present Mr. Robertson saying, we tried. The thing is I'm willing to bet they purposely never looked for him, and now Mr. Imes in his question there was trying to make sure they didn't get highlighted for them. And in interrupting with the court and speaking over the court, I got the ruling I wanted, I got what the court to say, let's get him away from that, and the court doesn't clarify that. They're now forcing a ruling that makes no sense.
And Mr. Levine never came back and said, well, wait a minute, okay, so we can't argue he's hiding, We can't argue consciousness of guilt. We can't argue all these things, but certainly we can argue that the prosecution never attempted to find him, and the prosecution never attempted to call him. He never attempted to clarify that.
And just if I didn't want to butt in, but I will. The court cleared it up. You cleared it up, Your Honor. You made it very clear what we could and couldn't do. So that's what we call Mr. Robinson for. He testified. To say that now we can't argue that would not be, I don't know, what the discussion that I would have with Mr. McGee would be that he couldn't argue that he was hiding or exactly what the court said. It doesn't mean that, so Mr. McGee wouldn't have known that the court said we couldn't argue anything.
Well, I think all defense counsel are required to be aware of the court's rulings, even if they weren't personally present at the time they were made. And certainly counsel has had some discussions on coordinating their arguments.
I gave Mr. Moline a full detailed outline of everything I was going to say, and I followed that outline. And in there was the listing of, they didn't call logical witnesses, and he was one of them. And there was nothing in that outline that was hidden, the fact that I was going to make that argument. And I think and he had plenty of time to review it. He said everything looks right. So if the court was presented with that question now, I assume the court would say, yeah, you're allowed to argue that. Because we're allowed to argue with Mr. Cicada. We're allowed to argue it with a number of other witnesses. I brought that up. Why is Mr. Cavanaugh being treated differently?
Well, for one reason is that there's evidence that someone tried to locate him and was unable to locate him. So that certainly raises the inference that he was not locatable for one reason or another. It is sheer speculation that the prosecution intentionally elected not to try to locate him so he could not be located.
When they heard our witness get up and say we tried to locate him, their rebuttal witness could have been Sergeant Smith or anybody else in the team, Investigator Moon, who's been working on the case with the DA's office, and say, yeah, we tried to. They had the opportunity. That wouldn't be rebuttal. Why would they call a witness to confirm your witness? Well, because they could say, yeah, that's an issue. We couldn't find him either. They didn't do that.
I don't think they would normally do that.
Because they didn't look for him, because they didn't want to call him.
Again, lots of speculation. Like
I understand your argument.
I think the crux of the issue is that the argument with regard to Mr. Cicada Sr. was different than it was with regard to Mr. Cavanaugh. The argument went along the lines of, they didn't call him, okay, and we would have wanted to ask him this, and we would have wanted to ask him that, and wanted to ask him that, and wanted to ask him that. And the reality is we're running right into the problem that we brought up at this hearing. And that is, they blabbed to the media all over the place that Dan Cavanaugh did it. What are the chances he's not going to invoke the Fifth? And then we're going to have to explain that to the jury. And on and on and on and on. So the argument with regard to Mr. Cavanaugh went beyond merely they didn't call him.
Okay, I'm agreeing with you that
I just want to make that clear.
That I at least initially agreed with Mr. Imes that they would not be able to make that argument. And it was never brought up again. There was never an attempt to clarify it or revisit it. And so that was the court's ruling at the time. So I'm willing to make that correction to the jury.
And just so it's clear, I think to make that correction and to call out defense counsel would be a violation of my client's federal and state due process rights. Sure. Right to effective assistance of counsel.
Okay.
Thank you.
So we can go ahead and bring the jurors in. So this was just an error. The record reflects we are back in session. Parties and counsel are present. All members of our jury are present. Before the defense continues with their closing statement, need to correct one thing that was brought up during Mr. McGee's closing statement. The prosecution objected to Mr. McGee's statement in his closing statement that the prosecution should have called Mr. Cavanaugh as a witness, that he was a logical witness. It was failure to call a logical witness. That was actually, the prosecution had to remind me of that during the break, but that was actually the subject of discussion that we had previously, where the court ruled, since there was evidence by the defense to try to locate Mr. Cavanaugh and they weren't able to locate him, that would not be a proper argument. So I should have sustained the prosecution objection to that, and so you're instructed to disregard that comment by Mr. McGee that the prosecution should have called Mr. Cavanaugh. And with that, Mr. Levine, you may continue with the defense closing statement.
Thank you. Good afternoon, ladies and gentlemen. Just want to start off by saying thank you so much for your time. This has been a long road. I feel I know you guys on some weird level, even though we don't talk to each other or even look at each other that much. But it's been a long time, and I know how hard it's been on your lives personally. I have to apologize for the delays, the technical mishaps, the endless sidebars that you have to sit through, all of it. It's not easy being in your seats, and we understand that. I also want to thank my defense team and the prosecutors and the court staff. So I want to just kind of pick up where Mr. McGee left off in certain respects. I'm not going to try to rehash everything, but if I do go over the same things, it's not for the same purpose necessarily. It's to highlight other issues. What I want to talk about first is there was a initial investigation by San Diego, and part of that investigation, right after Detective Dugall had interviewed Susan Blake and Mike McStay down at the house on 215 on February 15th, 2010. They then, the very next day, went to the San Ysidro shopping center, and Detective Dugall talked about that, about interviewing some of the security guards there. The prosecution called a witness by the name of David Jackson. He was one of the security guards. But David Jackson wasn't working that day, and we had Detective Dugall, who actually went there the very next day, as I indicated, and I wanted to share with you what Detective Dugall said in his testimony here, and it was part of the clip that Mr. McGee was going to play, but we had a little technical difficulty. So let me go to that and play that clip. That's the wrong one. I guess we're not going to play it. We are going to play it. Sorry. Oh, is it just the volume here, or?
Yes.
Okay. It's only coming. It's not. Oh, we're not on. We're probably not on here.
Your sound isn't set up like that way.
No, but we're on here.
Yeah, you're showing there, but so you can't play. You just get to read it to them.
We thought we had it all fixed.
Wait, we'll try
No.
this.
Okay.
Try this. Nope.
No.
So you just gotta read it to them.
Okay. Detective DeGaule's exact testimony. The question was, did you interview Mr. Murray? Yes. And based on what Mr. Murray told you, you went and pulled some surveillance tape, and you limited your surveillance tape to certain hours. Correct? That's correct. And the hours that you chose were based on what Mr. Murray told you. That's correct. And what did Mr. Murray tell you? From memory, he believed that it was the first time he saw it was around 5 p.m., I think he said. So that was Detective DeGaule's testimony. And remember, Detective DeGaulle, when he went to the San Ysidro Center, the issue was, when did the trooper get there on the 8th? What time did it arrive? Okay? And the prosecution, knowing what DeGaulle testified to, knowing that he talked to Mr. Murray, meaning Detective DeGaulle, and security guard Murray told DeGaulle that the trooper wasn't there before 5 o'clock. Because if it had been there before 5 o'clock, DeGaulle would have pulled tape, the surveillance tape, prior to 5 o'clock. He limited his surveillance tape from 5 o'clock on, okay? So it was very clear that the trooper could not have arrived at the San Ysidro Center before 5 p.m. And when Detective DeGaulle was asked if he was being thorough as he could, he said yes, and he even said that he went across the street to the other shopping center to pull their surveillance video as well, because he was trying to find out, when did that trooper get there? What time? Let's look at everything, okay? And he picked that 5 o'clock time. He was even being conservative. So he picked that 5 o'clock time because that's what security guard Murray told him. And security guard Murray also told him that he was the one working at the time, because he was the one that filled out that slip, that tow slip, and he signed it. On the issue of who was working, let's see, I don't think we're going to get sound. Are we? We're not. Okay. So I'm not going to play that clip, obviously, but Mr. Carter was a witness. He owned the security company. And when they asked Mr. Carter who was working that day, he indicated it was Mr. Murray who was working that day. He worked the shift from 3 p.m. to 11 p.m. Now, I don't know if you remember this, but it was Detective Hankey, Sergeant Hankey, I should say, who drove down to San Ysidro. This is 4 years later. This is done, these interviews, initial interviews were done right at the time, the very next day, in fact, on the 16th of February 2010, when everything was fresh in everybody's mind. Detective Hankey drove down there because, again, that's a problem for them. If the Isuzu trooper isn't there before 5 o'clock, that's a problem. So Detective Hankey drove down to San Ysidro in 2014 and talked to Mr. Jackson. And Mr. Jackson indicated, no, I was the one that was working the swing shift from 3 to 11. Well, that's not what your boss said. That's not what Mr. Murray said. That's not what Detective DeGaulle said back in 2010. But I don't know if you caught this in the questioning, but Detective Hankey and Mr. Jackson were talking about Sunday. Detective Jackson thought it was Sunday that he was talking about, because that's when he works the swing shift. And Detective Hankey didn't correct him. He let him think it was Sunday. And he got his statement because it was very clear that Mr. Jackson thought he was talking about Sunday, that he works the swing shift on Sunday. There was no need to interview anyone else again. It was very clear. They had the toe slip. There was Mr. Murray, when Mr. Jackson told them that, they didn't go back and interview Mr. Murray and say, hey, wait a minute. Jackson said he was working. Back in 2010, Murray, you said you were working. They didn't do that. And of course, in 2015, Mr. Murray passed away. So he wasn't available to be called as a witness to clarify that issue. But there was really nothing to be clarified. It was Detective Hankey going down there to get a statement to keep them in the game on that issue. We heard testimony about that initial interview as well. This is also part of that 15-minute clip that Mr. McGee was going to play, and I'm just going to hit a couple highlights. Number one, when Chase was interviewed in that interview, that was on the 17th. That was only 2 days after Susan Blake and Mike McStay were interviewed in the evening in the back of the detective cars. So it's just 2 days after that. And of course, Mr. Merritt indicated that they did the interview at the clubhouse and the Homecoming Apartments, which is where Mr. Merritt said they were living. They did the interview in a clubhouse, and I put an overhead photograph of that clubhouse at the time, and you could see, and I believe it was Taylor and Cathy Jarvis who indicated they lived maybe, I don't know, 30, 40 feet, something like that, from the actual clubhouse door. So, and since they spent time at the clubhouse, meaning the family, Mr. Merritt, his kids, they spent time there. If Cathy wanted to get a hold of them ever, what would we do? What would we do in our own homes? We would, are we going to walk over to their, to get our kids at the neighbor's house? Are we going to call them or text them? That's what we're going to do. We're going to call them or text them, which is exactly what Cathy did. That's why when you look through the records, the phone records for Mr. Merritt, because you'll have them back there, you can look through them, you'll see the same home tower that Kevin Bowles testified about, the home tower. There's hundreds of calls between Chase and Cathy that both ping off the home tower. Those are logical calls that Chase or the kids or whoever are in the clubhouse. And so there's a long history of calls being made from the same location. In that interview, Chase actually takes notes with him. And the reason he takes notes with them is because Detective DeGaulle asks him to. And he comments on it. Detective DeGaulle actually comments on the notes. He says, oh, we talked about that. And what Chase took to that meeting, or to that interview, was that February 1st email. Okay? And that was Exhibit 419. We've seen it many times. Bless you. So, Exhibit 419. Now, at the time that Chase gave this interview, this was probably 17 days old, this email. It's just a little bit more than 2 weeks. And along with this email, Chase also brought another document, and that is the spreadsheet that we've heard so much about. Okay? Chase took a photocopy with him, which is what he gave to Detective DeGaulle, and that's Exhibit 588 here in trial. And Detective DeGaulle actually took that spreadsheet and kind of filed it away. Chase was explaining in the interview what the numbers meant. And he was explaining to Detective DeGaulle that what the numbers meant on the email as well. So what Chase told DeGaulle was that he's explaining the overpayment situation and how it relates to the spreadsheet. Because he was showing DeGaulle that these match. If you look at these numbers, they match what's on this email. And that's how, he said, that's how Joseph and I keep track of our finances. Sometimes I owe him, sometimes he owes me. And that's what he was showing to DeGaulle. DeGaulle didn't really pay a lot of attention to it. Neither did Detective Fisk, but that's what Chase is doing. He's explaining what all this means. He told Detective DeGaulle that he writes checks, and he told him that he canceled Quickbooks and he wanted it deleted because he had ordered Quickbooks Pro. He told him all that in that initial interview. And he says that he writes checks. Joseph gives him checks. Do you know how many checks, ladies and gentlemen? You're going to have the bank records. You can look at them. You can actually look at all the checks. There's hundreds and hundreds of checks between Joseph and Chase. Hundreds, for all kinds of amounts. After all, look at the amount of the 2009 spreadsheet that Chase took to the meeting. See if I can blow that up. Because it's the same, we have a better copy with the newer exhibits, but, oops, I just rotated it.
The pluses in the center top.
Let's see. I'm going old school here. Okay, so if you look at the totals for 2009, we're talking about the total amount of business they had done in 2009, at least up until December 22nd. We've heard this many of times, but it was $297,954. That's a lot of money. Of that, 65% or close to 65%, at least at that time, was $158,000. Okay, that's the amount of checks that were given to Chase. So this idea that these 6 checks, 2 of which went to Metro Sheet Metal for whatever amounts, somehow provide some type of motive is ludicrous. This was normal activity for Joseph and Chase. When they get a job, ladies and gentlemen, when they get the money from a customer, no matter who the customer is, whether it's Saudi Arabia or anyone else, when they accept the money, when Joseph accepted money from a customer, they got to start work on it. That's what you got to do. If you don't start work on it, you start getting calls, like Susan Blake got when they didn't start the Saudi Arabia job right away. She testified, I had a guy from Saudi Arabia calling me. Well, that's what they do. When you don't start work and make progress, people call and they get upset. So the idea that Chase is getting checks, he has to get checks in order to start the work. This idea that Chase is getting money, yeah, he needs money to buy materials. He needs money to complete these jobs. Chase specifically tells Detective DeGaulle that there's 2 projects. There's the Saudi Arabia project that we're in the middle of and the Paul Mitchell project. And that's what they talked about at Chick-fil-A. He indicates that they went over those projects and Joseph gave him checks for those projects. That's what he tells DeGaulle. He also told them about the payments that they would have to be making to Metro Sheet Metal. Now, nobody really thought much of what Chase had back then until it became an issue in San Bernardino. And all of a sudden they wanted to use this QuickBooks and this financial motive issue. So then all of a sudden, money became important. Checks became important. But I would submit to you, ladies and gentlemen, that the entire investigative team, and I'm not doing this to put them down, I'm just telling it as a fact. They didn't really have a clear grasp of what their business was or what the history was, nor did they care. Because remember, once they locked sight on Chase Merritt, this stuff didn't matter. They didn't care that there was previous business and previous transactions. They could care less. And Chase is here saying, wait a minute, I told you guys about all this stuff. And they were not going to have it. It's all BS. Whatever Chase would have done was BS. It didn't matter. But then a funny thing happened. When our computer expert, Brian LaRocque, was searching the computer, Joseph's computer, and doing his forensic analysis, lo and behold, he finds the 2009 spreadsheet. I think this is it. This is the 2009 spreadsheet. This came straight from Joseph's Google Docs that was found on the e-machine. And the prosecution didn't know about it. And they didn't know about it because they didn't bother to look. It was on the computer that they seized. Detective Schroeder, their computer expert, had the file. I mean, it was in his list of thousands and thousands of pages. But if they would have looked, they would have found that, wait a minute, this was on Joseph's computer. This is not something that Chase manufactured. This was on Joseph's computer. And guess what? You're going to have both exhibits in evidence. You look at them, they're identical. There's not one difference. And this is Joseph talking. And this spreadsheet says plenty. It says a lot. And we're going to get into that. But one of the things it does say, right off the bat, is that all of these jobs here that we see, that are listed, that total $297,954, all of them were complete. Every single one of them. Joseph also tells us through this spreadsheet that when they begin work with Metro Sheet Metal. So if we go to the top, we see this Metro Sheet Metal column. And if we look down, when business started with Metro Sheet Metal got their first payment on October 2nd, 2009. Okay, so Joseph is telling us that's when we started work with Metro Sheet Metal, in October of 2009. Joseph is also telling us in this spreadsheet that they only did 10 jobs with Metro Sheet Metal, not including Paul Mitchell in Saudi Arabia. And these are the 10 jobs listed. They're right here in this column, because those are the only payments that Metro Sheet Metal got for jobs, excluding Paul Mitchell in Saudi Arabia. And everything that Chase had told San Diego, everything that Chase tried to tell the detectives in his 8-hour interview, which they basically said he was lying about everything, came to fruition. It's here. And that's Joseph talking. Chase also explains, ladies and gentlemen, very clearly to Detective DeGaulle that the way our business works, I'm a separate company. My company is called iDesign. Joseph has a separate company called Earth Inspired Products. I don't work for him. I'm not his employee. I complete a waterfall and then Joseph pays me. The structure we have, Detective DeGaulle, is I get 65%. Not profit, because as his own business, he has to now go buy all the materials to make the waterfall. And he explains to Detective DeGaulle that once he does all that, and Joseph verified it with all the checks that are written to Chase here and charged to him, okay, every single dollar amount listed here, that every single check he writes to Chase is charged to his account. He doesn't get it for free, okay? But all those dollar amounts there, Chase has to pay for. That goes as an amount paid to Chase. It's not free money. It's whatever checks Chase gets are debited to his account. So after he spends his money, after he buys the material, he's left with a profit of about 15 to 20%, in that range. He says on a $10,000 waterfall, I'm going to make $1,500 to $1,800. You all heard this already. You probably don't remember because it was a long time ago, but the whole audio interview was recorded. And Chase explains all of that right in the very beginning to Detective DeGaulle, how the arrangement is and what his profit is and what he makes and so forth. Now, I know it was boring, but we had a forensic accountant come in, and Mr. Sjogren, to explain what does all this mean? What is metro sheet metal? And how does that play into this equation of 65%? Because the prosecution would lend you to believe that he's making 65% and then he went down to 15%. And therefore, he's making less money, and therefore that's somehow some type of motive. Well, that's completely untrue. And it's untrue because Joseph is telling us it's untrue with his spreadsheet. And I'll tell you how. What Mr. Sjogren tried to explain, that what these spreadsheets show, is that on October 2nd, 2009, when payments were being made to Metro Sheet Metal, the profit structure changed from 65%, where Chase is going to be buying everything, to now Joseph is going to take over and spend and pay for the fabrication of the sheet metal, pay for the other items that need construction, and Chase was basically going to be dealing with the artistic creation of the waterfall, the stone, the glass, things of that nature. But materials would not be purchased by Chase. Okay? And the biggest cost, which was Metro Sheet Metal, would be paid directly to Metro Sheet Metal, starting in October of 2009. And so the profit structure changed to Chase now getting 15%. But guess what? He doesn't have to go and bend metal and buy it and all that stuff. He saves all that cost and the cost of goods as well, because now that's going to be borne by Joseph. But Chase is going to make about the same, because on the email, if you look at the new profit structure for the Paul Mitchell and Saudi Arabia jobs, that's at the top here. It says PM, 15%. Saudi Arabia, SA, 15%. Okay? And if Chase is able to reap some savings out of some suppliers, he can get that too. So if he makes a savings from Metro Sheet Metal and he can get it for less cost, some other goods, he's going to reap those benefits as well. And that's the new profit structure for Chase. He's going to make about the same money, maybe more, than he was when he was getting 65%. Okay? And Mr. Sjogren was trying to explain that. I know it was tedious, but that's what he was explaining when he talked about this issue. And it's not that Mr. Sjogren was saying it, it's borne out in the spreadsheets. Those numbers I'm telling you, 65% and 15%, if you look at those, they're all going to measure up. You can take your calculator back there and do the calculation yourself. It'll come out to those percentages, because that was the change. We heard from Cathy Jarvis. Cathy Jarvis testified that Chase and her had their first child in 1994. There was a break in the relationship. I think she indicated it was about 5 years. Chase was an artist making metal art back then in 1999 when they got back together. They started custom waterfalls, and they opened a shop in San Dimas. They opened another shop, I think, in Pomona, maybe a few years after that. It was at that time that Joseph got interested in Chase's work. Somebody had referred Chase. Somebody had referred Chase to Joseph, and Joseph ended up going down to the shop and meeting Chase and looking at his work. And Joseph decided that he wanted to be in the custom business. He had actually done a little bit of custom work before that. But the custom business is tricky. Unless you've got somebody that can build these nice waterfalls, you're not going to last very long. But not only build them, I guess, nicely, but build them cost effectively. Okay? Of course, Joseph could go and get his custom waterfalls done by one of these suppliers like Blue World, like we saw, but that's going to cost a fortune. So when Joseph goes to bid on a job, he ain't going to get it because his price is going to be too high. So to have Chase, it was a benefit for Joseph as well, because now Chase, since he was cheaper than Blue World or any of these folks, Joseph could now be competitive. She indicated that Chase wasn't great with money. She indicated she was the fiscal responsible person in the relationship, but Chase had a talent. He was very artistic, very creative, and he could build anything, is what she testified to. And he was a hard worker. And she said out of this meeting developed a business relationship that she saw blossom. We can see from 2007, the spreadsheet in 2007, they did $300,000 their first year together. I mean, they took off because Joseph could now be competitive. These waterfalls apparently are in very big demand, and if you can be competitive on price, you're going to get business, and that's what happened to them. And she said that through this process, Chase and Joseph became friends. That Joseph would come for dinner to their house, but not to the house, actually, to a restaurant they would meet at called Charlie's. She talked to you guys about one specific time that she remembered. I believe it was in 2009. And she said Joseph was giddy. He was excited about $1 million project, because they were talking about big projects then. They even talked about going to Saudi Arabia together, their families going on vacation to London or Saudi Arabia. She said Chase was happy. She said Chase didn't really have a lot of friends. It was difficult for him to have friends, to make friends. So for him to have Joseph as a friend really made Chase happy. She did say Chase did play poker. He was a poker player. He would enter tournaments and play poker. And the way she described it worked, the way it worked is once you buy in, if you can continue on and you can stay in, that could be hours. And he would be home when he was in a tournament or whatever, he would be home, he could be gone for hours. Yes, she did say that. She specifically was asked about February 4th. She indicated that she remembers February 4th, not because it was any day special at the time. It became a special day, though, because when everyone started looking for Joseph, and Joseph and his family were missing, it became a very important day. So she was recalling events of that day when she talked to investigators. And what she told them was that she remembered Chase was going to meet Joseph that day on the 4th, that they were going to go to lunch, that Chase came home from work, it was still light outside. She remembers Chase getting checks from Joseph, that he brought the checks, actually. And she knows this because it was a common occurrence. She said that happened all the time. Well, naturally, Joseph would have to give him checks to go and do these projects. As far as her recollection was concerned, that Chase remained home or at the apartment complex. Of course, he could obviously be at the clubhouse. Doesn't mean, she wasn't saying that he was necessarily right in the house, in their apartment, but he was in the complex. He didn't go anywhere, in other words. He didn't get in a vehicle and drive somewhere. She was very clear about that. Because when Chase got into the apartment at whatever time that was in the evening, she remembers a call came in at 8:30. And she's not mistaken. And you want to know how she's not mistaken, ladies and gentlemen? You want to know why that's not a lie or by somebody that is a close relative or a biased witness? I'll tell you why. Do you remember the interview she had with Detective Hankey that she was asked about? In that interview, they told her that she was lying. Okay? They told her that you're mistaken. That call never came in. You're wrong. Over and over again. Okay? She described the interview as being, I forget the word she used, but I think maybe hell. She described that interview. Because remember when they planted that wiretap, and she called Chase after that interview, and she told him about what they were doing. You guys will listen to that again, but she describes how bad that interview was and how long it was. But what they did in that interview, they told her, when she told them about that call, that would be a big problem, right, for their case, because 8:30, if Chase is at home, he ain't in Fallbrook killing anyone. So that's a big problem for them. So they told her that she's mistaken over and over again. You're mistaken. No, I'm not. Then they confronted her with records. Okay? Records. And they pulled out records. But the records that they pulled out were Chase's records. Well, we know that call from Joseph ain't on Chase's records. You guys heard that testimony several times. But they show her the 8:30 time. Look, no call from Joseph. And she's saying, now, mind you, she doesn't know that Joseph's phone records show it. She doesn't know that. If she's lying, then she's complicit in some nefarious activity with Chase, if she's lying. And she could be called out on that. If you are lying at that point, that's about the time that most people fess up. Okay? That's what happens when people get caught in a lie by the police. They fess up. And they say, okay, you got me, as the judge described. You can be lied to, and sometimes the purpose is to have the person say, okay, you got me. I was lying. No, that didn't happen. She stuck to her guns. She doesn't even know that she's going to be vindicated later on with a call record that shows there was an 8:30 call on the 4th. How would she know that? She would have no way to know that. But she stuck to her guns. Now, she believed it might have been a Friday. I mean, we've got to remember, this is in 2014 when this interview happened. She's being asked on the fly about a call from 2010. So if she's thinking it's a Friday, that's an innocent mistake. And the only reason she gives them Friday is because they press her that she's lying, she's lying, she's lying. So she says, okay, it could have been Friday. Or whatever word she used. So, of course, later on she was vindicated. When Joseph's call records, lo and behold, there's the call at 8:30. What's interesting is, just like in the email that I'm going to go over again with you, where clearly there's a credit for Chase Cumming for $26,000 for Paul Mitchell in Saudi Arabia, and the DA closes their eyes. They almost pretend like it's not there, like sometimes children will do. Okay, if they don't want you to find them, they'll stand right in front of you and they'll hope that you don't see them, and they'll close their eyes. That's what the prosecution's doing. With the $26,000 credit, they just simply gloss over it. They never even mention it. It's like it doesn't exist. Excuse me, time out. Let's look at the first 2 lines of that email. That's a credit. Okay? You don't just say $42,000. You don't tell the jury it's $42,000. At best, you tell them it's $42 minus the $26 he's getting for Paul Mitchell in Saudi Arabia. But in that same vein, even in this trial, ladies and gentlemen, in this trial, DA Rodriguez confronted Ms. Jarvis with those same call data records of Chase's and says, see, the 8:30 call's not here. Excuse me, Ms. Rodriguez, we have the Joseph's records, it's on there. It's almost like they want to will it away. If they close their eyes long enough, it'll just go away. It's not going away. The fact of the matter is, this relationship that Cathy describes is not a relationship where Joseph is going to fire Chase. He can't fire Chase. They're in the middle of Paul Mitchell in Saudi Arabia. Plus, they're on the cusp of some very big projects. $1 million projects. Big projects. They're only expanding. They're only going up, up, up. And quite frankly, ladies and gentlemen, Joseph needed Chase. He did. Who else is going to build that quality of a waterfall for that price where Joseph can be competitive? There's nobody else. He couldn't fire him. They talk about Walker Metal. They don't even, the prosecution doesn't even understand the business, ladies and gentlemen. You can't get Walker Metal or Walker whoever to build a waterfall. All a sheet metal company is going to do is be able to bend the metal. You still need someone to build a waterfall. Make it pretty, aesthetically pleasing. Don't they understand that by now? Or do they just close their eyes to that fact? You can't just replace Chase with Walker sheet metal or whoever. Joseph needed Chase. And she indicated that Chase needed Joseph because of his friendship. She said he helped him move. She took him to the airport to finish the Saudi Arabia job in May or June. He had long been paid for that. Saudi Arabia was in the books, but it took time for the crates to reach Saudi Arabia. It took more than 2 months for that ship to go from wherever in the United States
Objection
to
is
Saudi
in
Arabia.
facts, not in evidence.
Well, Cathy Jarvis testified that it was in May or June that she took Chase to the airport to go to Saudi Arabia to finish that Saudi Arabia job. And for all the prosecution's insinuations about poor quality work or not completing jobs or whatever the heck they said, okay, whatever they said about that, there was not one lawsuit produced. There was not one witness who came in and complained about a job, not one customer about the quality of work or anything of that nature. Not one. Oh, wait a minute, Geis Construction. Sorry. Red herring, ladies and gentlemen. Complete red herring. And they grabbed onto it. The prosecution grabbed onto Geis. Okay? But remember, Geis was a job that happened after Joseph disappeared. That was after. And the finances for Geis are completely unrelated to anything that was happening before. Because when Joseph disappeared, the set financial structure that they had was in disarray. Basically, this is the mode of operation after Joseph disappeared. We're panicking, we got to get this stuff done because we got people calling. Remember, Geis had called San Diego, he called De Gaulle. Where's it? We're not getting any answers from these people. Okay? And where did the Geis money go anyway? The Geis money went to Dan Cavanaugh and Susan Blake. Not to Chase. Now, the prosecution is...
that misstates the evidence.
It went to Susan Blake through the company that she set up with her son called earthinspiredproducts.com. And so, and when I asked the president by the way, when I asked the president of Geis Construction, Mr. Martin, when he was here, where did that other money go? Where did the other $62.50 go? Because the numbers, he didn't know where it went. He didn't know where it was sent. He thought he sent it to Earth Inspired Products. It actually, no one knew. Where did it go? $62.50 is missing in our calculation until we got the Chase records for Earth Inspired Products. They were actually subpoenaed during trial. And that's when we found out that Mike McStay and Susan Blake had opened that account. And that's when we found that $62.50 from Geis Construction went to them. Now, the prosecution is quick to point out that $5,000 of that money, of the first payment that was sent to Dan Cavanaugh, because remember, on his invoice, I pointed out to Ms. Hackman, I believe her name was, from Geis. I pointed out to her that who does it say the remittance is supposed to be made to? And on the bottom, it said Dan Cavanaugh. It had his email on the bottom of the Earth Inspired Products invoice. So that's where they sent the first money. And they're quick to point out that Dan Cavanaugh quickly sent $5,000 to Chase. And this is towards the end of February or beginning of March. And somehow that Chase would have known that that $5,000 is for Geis. How would Chase know that? Chase is now scrambling because he couldn't get them to give him money to finish the project that they had to finish. Chase doesn't know it's anything to do with Geis. He doesn't know, and he doesn't. So he doesn't work on it until Geis contacts him directly, and then he's saying, I don't have any money for that. The $5,000 that Dan Cavanaugh gave to Chase, how do we know what Dan Cavanaugh told Chase that $5,000 was for? Chase is scrambling to keep this business afloat. That's why he went down to San Diego with Susan to confront Cavanaugh. I want to talk about motive, and that's CalCrim 370. And I don't think I have it on this, but we've already gone through that, and I know Mr. McGee did. But the reason I want to point that jury instruction out to you is because it says a couple things, and it means a couple things more. Is it here?
Keep talking.
Okay. So, motive, CalCrim 370, it's one of the jury instructions that the judge read to you, okay? And basically it says that the people are not required to prove that the defendant had a motive to commit the crimes charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Not having a motive may be a factor tending to show that the defendant is not guilty. That makes sense. However, having a motive cannot prove guilty by itself. So, basically you can't use it on its own to say Chase committed the crime, even with all the motive type stuff we heard. But the law doesn't seem to give motive much value, because it's not enough by itself. You need other stuff, right? So why is that? Why do you think that is? Well, because motive is easy to make up. It's very easy to make up stories about people. So if you start allowing motive to be enough to carry the day, gosh, you can make up stuff about anyone. Look at when Mike McStay was on the stand, okay? I did a little exercise with him about his truck. It just happened to be the same truck Chase drove.
Objection misstates his testimony.
Okay, almost exact.
Objection misstates his testimony.
He also told, Mike McStay's also the one who told Deputy Tingley that he was actually at Joseph's house on the 4th and the 6th, or the 6th. Okay. And Mike McStay's also the one who applied for a loan saying that he was the owner of Earth Inspired Products. Now, did Michael McStay do this? We don't have any evidence of it. But through sinister questioning, through looking at someone with an evil eye, and casting unwarranted aspersions towards that person, you can make people look bad. Okay? And that's why motive doesn't have that much value. Okay? And their whole case is motive. They've spun a lot of tales to you. They've given you half-truths. They've given you one portion of an interview and not the other.
Objection, misconduct on the rules of professional conduct 8.4. Admonish the jury, please, Your Honor.
I would like clarification on that. Well, they presented evidence in QuickBooks. They presented Ryan Baker. He got a call on the 9th of February. Remember that, ladies and gentlemen? And Ryan Baker testified that Chase deleted, or not Chase, but Joseph McStay, because that's the name of the account. He deleted he needs it deleted, capital letters, needs it deleted. Okay? They've made a big deal about that. But they failed to tell you about the call that was made on the 8th, the day before. On the day before, Chase called on the Joseph McStay account, the custom account, and ordered QuickBooks Pro. And that order be sent to Joseph's residence, or his business, or whatever address they had on file for him. Okay? Now, the purpose of that is to take your online activity and put it on a desktop. So the following day, he called to have instructions sent, not anything deleted, nothing deleted, but have instructions sent to Joseph on how to delete it once the information is downloaded from QuickBooks Online. Okay?
Objection misstates testimony.
And you heard from Annette Drone. She's the supervisor who came in and testified in our case. And she said that's common. That's what people do. If you order QuickBooks Pro and you put it online, then you want to get rid of the, you put it on the desktop, you want to get rid of your online activity. Okay, for privacy concerns. There's a whole host of reasons for it. But that's the purpose of doing that. It's a very common thing. But not the way the prosecution presented it, because they only gave you Ryan Baker on the 9th. And Ryan Baker, by the way, remember those screens that he looked at? He didn't know anything about the call the day before. He didn't know that QuickBooks Pro was requested the day before. That is not giving you the full picture, ladies and gentlemen. That's creating false motive. That's making up a story to fit what they wanted to say. Going back to the 2-1 email real quick. Oops. I did something bad. I think I erased it. Oh. Okay. I think I hit the wrong button. But anyway, that email has 2 lines at the beginning. Paul Mitchell in Saudi Arabia. And it says 15%. And on those 2 jobs, now remember, Joseph has already been paid for both those jobs, at least the initial payments, in January. They're on his bank statement. Okay? He got those payments, so that work has to get done. But that's a booked job. So that money, that $26,000, which represents 15% plus the savings, okay, that is money that is due Chase. That's a credit that is coming to him on that, okay? So when you have the total overpayment of $15,000 and a credit that's coming of $26,000, it's actually Joseph owing $11,000 when that credit is applied. Is it up there? No. Oh, anyway. So again, they don't mention that $26,000 credit. Close your eyes. And what about the $42,000? So they have $15,000, and then they add Provecho and that Levine job. Okay? They add Provecho and Levine. Well, Joseph didn't add it. It's not in his spreadsheets. It's an off item. Off balance sheet item, I think Mr. Sjogren described it as. Because it's not included in their everyday calculations of who owes money to who. Okay? And that makes sense, because it's a disaster, as Joseph described it. It doesn't mean that Chase didn't build a waterfall for them. It doesn't mean that Chase, remember, he's a separate entity. He did his job. He got paid for it, $19,000, but he delivered a waterfall. So he should get paid, right? I mean, that's kind of the way it works. He's a separate company. But Provecho defaulted. You heard that from Mr. Sjogren. He read the claim. The judge even asked him about it. The judge asked him, what did you learn about Provecho? And he told him it was a claim that was pending because they withdrew their initial credit card deposit. That has nothing to do with Chase. That's a credit risk that Joseph took. He's a separate company. That has nothing to do with Chase. Now, if Chase agreed to pay for part of it because he has an ongoing business relationship, that's what business people do sometimes. There's nothing nefarious about that. In fact, Chase is being a good guy by accepting part of the responsibility, even though he really doesn't have to. If he did the work, he's a separate company. And that's why Joseph doesn't have it on their running tally. So to say, for the prosecution to just add that in, when it's clearly not a part of the calculation, and just to tell you that there's a debt of $42,000 is misleading. Those 3 ledgers that were found on Joseph's computer, 2007, 2008, and 2009, there's 156 jobs that were completed by Chase and Joseph. Even though Joseph doesn't really do the hands-on type stuff, 156 jobs he completed. 7 hiccups. When you guys look at those ledgers, if you choose to look at them, you'll see that there's some comments there that there was a problem with this one or a problem with that one, the customer didn't pay, whatever the issue was. But a total of the 156 over 3 years, 7 hiccups, and 2 disasters, Betcha and Levine. That's it. But every single job was completed. Now, the prosecution criticized Mr. Sjogren, who was putting these financial numbers into a way that we could all understand what's really going on between Joseph and Chase. And I forgot who did the cross-examination. It may have been Ms. Rodriguez. But she went after him because I'm not sure why. I'm really not, because she should have been, okay, tell me more. Let's learn about this financial situation. Because you know what, ladies and gentlemen? They didn't hire anyone to do anything. Okay? We heard from Mr. Weitzman, who didn't give us a report about what he was going to talk about, just graphs. You know what his graphs were? How much money Chase withdrew at casinos. Cash, remember that? There was some GICs or some other type of special thing that they were talking about in terms of withdrawing cash. But essentially what he did is he provided a list of all the cash that he withdrew, that Chase withdrew, over whatever period of time he did it. That's all he did. How does that help anything? Based on their relationship, Joseph and Chase, the way they did their running ledger, it didn't matter what Chase spent the money on. If he was up 1 month and he was down 1 month, that was between them. As long as the waterfalls got done. Okay? If Joseph gave Chase a check and Chase decided he wanted to blow it on a Ferrari or blow it on a new car or go gambling or do whatever, he could do it. It's going to be on the spreadsheet, though. It's going to get charged to his account. Okay? There's nobody, not one person, that has come in to tell you that Chase owes any type of gambling debt. Yet, Ms. Rodriguez,
Objection to Ms. State's testimony.
there's not one person that came in and said that. Now, there's been innuendo in their questions. Don't be confused, just like the judge told you. There's no evidentiary value in the questions that the attorneys ask, unless it helps you explain the answers. So, the questions insinuating a gambling debt or a gambling problem or anything of that nature, there's no one that's come in and testified to that. Mr. Cicada. I'm sure Mr. Cicada and Chase were super duper close. No. Mr. Cicada doesn't know Chase. The DA in this case has hidden the truth from you. And they set out on a course to hide the truth from you. You heard from Brian LaRocque. He testified about PayPal records, and you also heard from a representative from PayPal, Sarah Kane. Not Joseph's PayPal records, although you heard about those too. I'm talking about Dan Cavanaugh's PayPal records. Do you realize, ladies and gentlemen, that the prosecution never even requested those PayPal records? Do you realize that law enforcement, Sergeant Smith sitting here and his team, never even requested his PayPal records? So they didn't know that Dan Cavanaugh had diverted payments from the production business online to his own account. They had no idea because they never requested it. Even more shocking, they never requested Dan Cavanaugh's bank records. So when Dan Cavanaugh financial history came into the spotlight, they didn't even know. They had no clue because they didn't even request it or look at it. That was something that we did. We got those records. And you'll have those records that you can review in the back. And you'll see Dan Cavanaugh's records. You'll see how Dan Cavanaugh, on February 10th, either the day after or the day of, he makes the call for a welfare check on his friend, Joseph McStay. He's dipping into his PayPal account and stealing Joseph's money. Mr. Sjogren testified that never one time before that day on February 10th, not once, had Dan ever helped himself to Joseph's account. It was always, he makes a request to Joseph, and then Joseph sends him whatever money. That's the way that it went. Mr. Cavanaugh never just went into Joseph's account and took money, but he did on February 10th. And guess what? For the next 2 weeks, actually for the next 3 days, he took another $4,000, $5,000. For the 2-week period after Joseph disappeared, Mr. Cavanaugh helped himself to about $13,000 out of Joseph's PayPal account. Why would he do that? Remember the payments he got before Joseph disappeared? $50, $25. That was the amount. Those are not the kind of payments that Joseph was expecting to make to him. Did Mr. Cavanaugh think that he wasn't coming back? I mean, Mr. Cavanaugh had to have known when he was dipping into that account and swiping $13,000 right off the bat that there's going to be a problem when Joseph gets back. Unless you know he's not coming back. Dan Cavanaugh's PayPal records were also revealing in another way. Because PayPal, unlike Quickbooks, provided us with IP addresses. IP addresses telling us where the device that is accessing the internet is located.
Objection misstates his testimony.
Where the device is making the connection with the internet.
Objection misstates testimony.
That doesn't mistake the... Yeah. Anyway, so we saw the IP addresses, okay? And we saw that, yeah, from January 11th to January 14th, his IP address is registering in Hawaii. Fair enough. But from January 26th on, it's San Diego. How is that possible if he's not in San Diego? Well, maybe there's VPN. Maybe you could VPN in. Maybe. But Mr. LaRock testified this was not a VPN situation. Why? Because on the 11th through the 14th, he's accessing from Hawaii. He would be VPNing from those dates as well, but he's not. He's actually registering and hooking up to the internet in Hawaii. And in order to VPN in, you would have to have a residence or a place, and this is the time that Mr. Cavanaugh, according to Mr. LaRock, did not have a home. He didn't have an address. Where was he
Objection, that
VPN?
assumes facts not evidence either.
Now, this is information that you have to have, and we presented it to you. We got those records. They were free to call an expert to counteract what Mr. LaRock said, to say that, Mr. LaRock, you are wrong. This is a VPN. This doesn't reflect where this Mr. Cavanaugh is. They could have done that, and they didn't. Mr. LaRock's testimony about IP address and what it stands for remains uncontroverted, untested by the prosecution. They didn't call a witness to say he's wrong. If Mr. LaRock was wrong, why didn't they do that? Now, when Lauren Knowles testified, she testified that she came back from Hawaii on February 17th. And she said that her mother purchased the ticket for her when she was in Hawaii. Okay? She also testified, when I asked her directly, are you afraid of Dan Cavanaugh? She didn't just say, oh no, not, absolutely not, he's a jolly good fellow. No, she stopped and she paused. And she was scared. But she didn't use that word. She said, I'm concerned. Okay? There's something there, ladies and gentlemen. And you know what? It's mind-boggling. It truly is. That since 2010, they haven't been able to get a ticket or a boarding pass or verify that he was in Hawaii. How is that possible? 2010, ladies and gentlemen, that's 9 years ago. Shut Moline up and get a dang ticket. Shut me up and get a ticket. Miss Knowles, Lauren's mother, sent them the ticket. We're requesting a ticket. She sent the ticket, and she sent the boarding pass. Because that's what you get when you buy it. You get it, and send it to people if they ask for it. And all these years, they can't get a ticket or a boarding pass. Oh, and these photos? Well, the dates on the photos, those aren't the dates of the actual date that someone's at a particular location. That's the date she uploaded it to Facebook. And by the way, why not just have the detectives access her Facebook account? Make them a friend or whatever, okay? Just like they did with Quickbooks. They got a clone. They were able to go in and do their thing. Why does she have to screenshot it and send it to them? That's kind of odd. Why does she send an email to Dan on the 26th saying, when are you coming back? If you go to the store, you don't get out your email account and email someone, you text them. You don't email them. Why is she sending an email to Dan on the 26th saying, when are you coming back? Where'd you go? The fact is, ladies and gentlemen, law enforcement didn't care about Dan Cavanaugh. It didn't. If they talk about financial issues being a motive in this case, Dan Cavanaugh took in $206,000 from the online account. $206,000 in a 10-month period from February to December of 2010. Money that should have gone to the McStay family. Yeah, it should have gone to them. Prosecution is quick to whip that, oh, wait a minute. He spent money. You saw the purchases to Blue World. Yeah, 50,000 of it. 50,000 of it. He had to keep the charade going somehow. Okay, so he bought a few waterfalls here and there. That means he kept $150,000+ that he stole. That's why he had to sell the company. And by the way, how do you sell a company that ain't yours? Did anybody ask him? What was happening with Dan Cavanaugh and Joseph at the time of the disappearance? Well, law enforcement didn't really look into it, so we don't know much about it. But we know a little. We know from MacGyver, Joseph's close friend, that he had bought him out. MacGyver's testimony and what he told investigators was he had already bought him out. He'd already paid him. It was done. We also know from the interview that Chase did with Dugal back in 2010. And it wasn't like Chase was trying to throw Dan under the bus because he didn't even know him. But what he heard from Joseph was, yeah, there was this issue of a buyout. He had a little bit more to pay, maybe $2,000 to pay. That's what he knew. That's what Chase knew. And as far they asked him, does he live in Hawaii? Is he in Hawaii at the time? Chase said, yeah, as far as he knew about Dan, he lived in Hawaii. He didn't know because he had never met him. He didn't know who he was, really. So it wasn't like he was saying, yeah, go look at, Dan Cavanaugh. No, it wasn't even an issue. He was just saying, this is what I know. And he also said that Dan was threatening to shut the website down. Okay, so we got a little bit of a glimpse there of what was happening at the time. Now, we also know from MacGyver that Dan Cavanaugh kind of started with Joseph in this business, right? He built this website. I think he referred to him, MacGyver referred to him as a web guy. I think that's the reputation that Dan Cavanaugh had, was a web guy, a guy who was good. Even Chase told DeGaulle he's adept at the internet. That was his reputation. And by all accounts, this website was doing good. Traffic was flowing. That's how they were doing that kind of business. But you know what? We also know that Joseph he had bought him out. He wasn't sharing the profits of the custom business. Okay? He wasn't sharing those profits. Now, what's doing better? Is the custom business doing better? Is that on the way up? Or is the production business doing better? Seems to me like the custom business was the one taken off. And who might have been responsible for that? Maybe somebody who built the website, created it, got the traffic to flow there? Well, does betrayal come to mind? Did Dan feel betrayed by Joseph, by cutting him out, when he's doing all this business with Chase? They want to fix motive, financial motive, greed, I think they said, or forgery. Those are not the human emotions that cause you to bash 4 skulls in. It doesn't work that way. That's not our human experience. For $42,000 or $20,000 or whatever amount, if it's money, and to forge 4 checks for $10,000, $15,000, whatever those checks came to. That's not the way our human experience is. But our human experience also tells us that there are emotions that can cause us to act in a way, that can amplify our anger, can make us uncontrollable. And I would subscribe to you, ladies and gentlemen, that betrayal is one of those human emotions. Betrayal, after all, if you look through history, is responsible for countless wars, deaths, you name it, destruction. Betrayal is a very powerful human emotion.
Let me interrupt you at this point. We'll go ahead and take our afternoon recess, 15 minutes. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case,